and the house sale fell through 2 days before we decided, or before we went into closing, and they had asked to move in. We said, if you pay the mortgage, we drew up a lease based off of them purchasing the home, and this is where we're at. So what happened is then they just stopped paying, and now
how much do they owe in rent?
So it was a $5,000 for 4 months. So that would be a total of $20,000. And we also missed out on listing the home again because they have refused to not leave.
We've gotten screenshots of proof of funds. We've also been told that ACH has been sent. We received a tracking number at one point that actually never registered with the U.S. Postal Service. And so there's been a lot of like, we're going to pay, and we have yet to receive anything.
We're leaving. We'll be out by the 1st.
I'm going to expect that if you have not surrendered the keys, that you will be in court and in a position to surrender keys to the Lepics at that point. Okay. Then we'll look at what money's there, because then that doesn't run, and we'll figure out what's owed and how that's going to be paid.
I will say we're moving to Seattle, Washington. I will make plans to appear in court in person, but depending on what our living situation is, then it might complicate my ability to show in person. Is there any recourse?
Ma'am, you need to get them the keys.
Oh, I can easily get them the keys regardless.
Okay.
And as of right now, they're still moving stuff out of the property. There are still people on property, including a couple of unauthorized additional roommates that weren't included in the lease. And we have yet to get in contact with Mr. Elliott. He is the named person on our lease. So we would just like to see what his status is. We haven't heard from him since the 7th.
Ma'am, are you moving out?
Yes, we've returned the key. I have a couple of friends currently helping me move out the remaining things. I'm actually at the U-Haul Center right now, and they are getting the rest of the items out presently under the supervision of the land manager.
Your stuff
You're
is
already
still
out.
Right.
And they have surrendered the keys?
Yes, and it's in the process of being removed as we speak. So we are out. It'll be another hour or two, I think, before it's all of our stuff is gone.
So then the only issue is what's owed.
Right. Oh, I also want to bring up, if I may, Your Honor, we were subjected to a wrongful lockout, so we are due 3 times damages of the $150 for a locksmith as outlined in Michigan's anti-lockout statute, totaling $450, which I also have evidence of.
Okay.
They were pocketing the rent that their roommates paid. They've just been sitting in my house, sir.
This is incorrect.
Okay. All right. Possession is not.
Sorry.
Pardon?
There are still people at the house. One of them had a residence established there, apparently.
I might as well, because the parties don't seem to agree, set this matter for trial. So non-jury trial in this matter then will be set for February 18th, 2025, 9 a.m. Okay?
And understood. And Mr. Elliott?
He needs to appear. If he doesn't appear, then I do what I gotta do.
And I have a history with you enough to know better. Ma'am, it is not my fault you got knocked up 6 times and now have that many mouths to feed. Apparently your ex-husband has some stories. So here's what I'm going to do. I'm going to file an affidavit attesting to my evidence, and even if you try to keep me out of court, Judge Simpson will still have everything.
Elliott and Burrell. Are they here?
I'm here, Your Honor.
Elliott.
Why aren't they here?
I'm here, Your Honor.
Ms. Burrell was dismissed. She's not a party and she's not a lawyer.
Your Honor, if I may.
Go ahead.
I have evidence. I didn't know whether I was still allowed to appear in person as a result of the notice to have me dismissed. My partner is not able to get off work, but I have evidence for the court in defense of
Well, I
my
can't,
partner.
ma'am, I see now the notice of dismissal. You've been dismissed from the case. He's not here. He needs to be here.
Understood. I've been messaging with my partner to see if they can do something to make it. On the meantime, I do have evidence that I have been given that I can put forward.
He needs to be here.
Okay.
If not, I'm going to default him because he needs to be here.
Understood.
When is he going to get here?
I don't know. Again, my partner is in the middle of work, doing everything that can be done to be present.
It's to be fair to each side. I give him 20 minutes. He's got to be here. If not, I'm defaulting him. Will that work for you, Mr. Lloyd?
20 minutes it is, Your Honor.
All right.
10:15 our time.
Okay, that works. Lepic versus Andrew Elliott.
Yes, here.
That's Mr. Lepic, right?
Yes.
Andrew Elliott. No response. Would you like to take a default? I gave you. All right, raise your right hand. Do you solemnly swear affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead, your claims.
Your Honor, there's doing already right now the amount of 15,000. There is active water bill that hasn't been paid in the amount of 584. There is a question, Your Honor, about late payment charges, and if you want, I can address those. The court had commented on in the last hearing, and because of the amount.
Yes, and they were rather large.
Might I make a pitch?
Certainly.
Your Honor, what's going on in this case, I agree that as a purely landlord tenant case, the amount of the late payment penalties is large. But in the context of the sale of the real property based out of earnest money and late performance of a purchase agreement, the amount is perfectly normal. I mean, I'm told that this was a $700,000 home. Sold normally you can afford to over 2% of earnest money. And so in terms of a good faith attempt for the parties to establish a number that could reflect the consequences of the default, I think the late payment charge is large, but not unconscionable. What the standard of the court rate.
I think it is, well, I would say that the late fees are unconscionable, and also the late fees can't be liquidated damages. In the scenario you put up, they could be in a certain respect. In this instance, the late fees have to be related to the landlord's ability to collect rent in some reasonable amount. So I would not allow them. If you want a hearing on that, you show it to me, then.
I see it a different way. In the context, I think I am less shocked because I see that 2% would be a typical earnest money deposit. This is less than that. But in the context of monthly rent payments, I'm not going to make that argument. Your Honor, there is now, we have an not earnest money, a security deposit that I want to be applied. I've got damages of $15,584. We'd like to apply the security deposit of $8,550, and what we'd like is a judgment in the amount of $7,034. I don't have my costs.
7,000.
034.60. And that's the net judgment.
After application of the
After application, I have a judgment for the.
So here's what I would do. I would take your total, make it clear under the further orders provision that the court is permitting this security deposit to be deducted since they vacated the premises, so that the full judgment is actually the full amount. and then the security deposit being deducted. So that we don't have, because I think there's going to be a problem if we do it the other way.
I have prepared a form, if you can see, let me fill it out, I'll prepare it, I'll offer to the court. I've got it right.
All right. And your court cost in this case, I have 130. I don't.
Process, here we go, and we got 75.
I have the process serving. I have a 0 service fee on both. I have no service fee. Okay.
So that would give us 205, I believe.
Yes, 205.
I will present it.
All right. Thank you.
At this point, the judge gives Elliot one final chance. In an effort to be fair, he allows 20 extra minutes for him to appear in court. It's the last opportunity to avoid a default ruling. The courtroom pauses while the clock ticks down. But when the case is called again, the result is exactly what many expected, still no sign of Andrew Elliott. The judge asks once more if there's any response. Silence fills the courtroom. With no defendant present and no legal defense being offered, the judge moves forward. The landlord is sworn in and begins presenting the financial claims tied to the months of unpaid rent and property damages. What started as a simple missed payment has now turned into a full financial judgment waiting to happen. Now the numbers finally hit the record. The landlord tells the court the unpaid rent alone totals $15,000. But that's not the only bill. There's also an unpaid water balance of nearly $600. The landlord's attorney attempts to include large late payment penalties tied to the original purchase agreement of the property, arguing that the financial consequences were meant to reflect a failed real estate deal worth $700,000. But the judge isn't convinced. He pushes back hard on the late fees, calling them excessive and legally questionable. In landlord-tenant disputes, penalties must be reasonable and tied directly to actual damages. After reviewing the arguments, the judge makes it clear that while unpaid rent and utilities can be enforced, the extreme late fees won't be allowed. In the final moments of the hearing, the court calculates the final financial outcome. The landlord explains that damages total over $15,000, but there's also a security deposit that can be applied to reduce the balance. After subtracting that deposit, the remaining amount comes out to just over $7,000. The judge agrees with the calculation and orders that the full judgment reflect the total damages first, with the deposit officially deducted afterward. Court costs are then added to the final number as well. With the defendant absent and no defense presented, the ruling is straightforward. What began as a broken home purchase agreement ended as a costly legal lesson. In the end, failing to show up to court didn't just hurt the case, it guaranteed the outcome.